Hello students, today I am going to talk about an important news which has been reported on the very first page in the Hindu that talks about the curbing of speech made by the minister. So the question arises that what the Supreme Court has said in this regard. We will see the conceptual part of this particular news, that is balancing the right of Article 19 and 21. We will see the idea of collective responsibility which has been questioned during the judgment. But before that, I just want to tell you the background of this particular news. So what has happened in 2016, that there was a gang rape in Bulandshahr, and after this gang rape, the minister of UP, Mr. Azam Khan, has made a remark that it is a political conspiracy. But this is a very charged statement, or you can say that this is a very charged response from the minister. And every time we have seen that the ministers or cabinet ministers, or whether it is an state ministers and all, they are making such comments on such sensitive issues which often is questioned by the civil society. And in this context, there has been a petition in the court that whether there should be any restriction on the free speech made by the minister or not. So I just want to raise two questions which have been answered by the court here. The very first question is whether the ministers are free to speak anything, whether there should be reasonable restrictions on their free speech under Article 19 Clause 2 is applicable or not. These are the two questions which has been highlighted. Now this question has been answered in 2016 by the third judge bench, and along with this they have said that this matter will be resolved by the constitutional bench or the 5-judge bench. Now this matter has went before the 5-judge bench, where the judge V. Subramaniam has given a majority judgment and B.V. Nagarathna has given a dissenting remark on this particular issue. Now we will see that this is the background which I have discussed with you. Now we will see that what Justice V. Ramasundram is talking about in this context. So he is telling that the Prime Minister or the Chief Minister is not responsible for what minister had said. And therefore, the idea of collective responsibility cannot be invoked in this case. And their judgment is based on the premise that every time and everywhere there cannot be a whip on the particular minister. And whatever they are telling, that is not a responsibility of the government. For example, a minister is telling something, how PM Modi will intervene and will ask him to keep his mouth shut. अभी कुछ कह रहा हूं मैं, जैसे अभी कोई आके मेरे मुंह पे हाथ तो नहीं रख देगा कि ये नहीं बोलना है. This is not possible. And along with this, this particular judge who has given his majority judgment has also said that already there is a reasonable restrictions under Article 19 Clause 2, which is very exhaustive in nature. We can put a reasonable restrictions on the free speech by the minister only on the grounds which is mentioned under Article 19 Clause 2. These are the two things which has been said by the Justice V. Ramasubramaniam. Along with this, he has said that if a minister is telling something and another individual is considering it as a violation of the constitutional rights or as the violation of the fundamental rights, then it will not be considered like this, but it will be considered under the meaning of constitutional tort. So what is the meaning of this constitutional tort? Constitutional tort means that if something has been violated by any particular minister of the government, then the government is responsible for this violation. And whenever he was giving his judgment in 179 pages, then Justice V. K. Nagaratna has given a dissenting remark. And she has said that no, a state is responsible for anything which has been said by the minister if the minister has said something that is related to the government. It simply means that if minister is telling something which is not related to the government functioning and which is not related to the government, then it will not be considered that his speech is equal to the speech of the government. So he is simply telling that, a minister's statement, if traceable to any affairs of the state or for protecting the government, is being considered as the speech of the government, and therefore collective responsibility should be invoked. So he has given the dissenting remark that we should invoke collective responsibility, but the majority judgment of Justice V. Ramasubramaniam is of the view that collective responsibility cannot be invoked in this case. So again, the second argument of Justice V. Ramasubramaniam, which I have discussed with you, has been negated by the dissenting judgment. Likewise, that they are required to understand. It means that ministers are required to understand and measure their words. So whatever they are telling, they should know that they are the public figure, and whatever they will tell, it will have an effect. And therefore, if it is a violation of Article 21 of another individual, then it would be a case of balancing the conflicting rights. It means that Justice V. Ramasubramaniam was telling that if a minister is telling something, and if it is taking the rights of another individual under Article 21, then it is not the violation of the rights of an individual, but it comes under constitutional tort, meaning of constitutional tort. But she is of the view that if minister is telling something and it is taking Article 21 of another individual, then we need to focus upon that how we will balance the rights of an individual under Article 21 and the right of the free speech of the minister under Article 19. However, she has also said that, okay, Justice V. Ramasubramaniam, if you are telling that it comes under the meaning of constitutional tort, so there must be a rule, there must be a framework that when and how constitutional tort will be applied. So that's all about the meaning of this very conceptual topic which has been discussed today in the Hindu newspaper. If you have any question, if your doubt persists even after watching this video, you can write in a comment box. And you will have to understand the importance of this topic, that it comes under fundamental right, and you can use this as a case study whenever you are writing any question on freedom of speech and expression and its relation with the ministers. That's all about today's video. Thanks to all of you.